Item number 1, announcement of judgment.
On the judgment, okay.
Just the conclusion. Let the writ petition be treated as a petition for review under instruction 162D and be tendered before the state government, which shall within 90 days of receipt of the papers upon hearing the appellant writ petitioner and other interested parties, and by a reasoned order decide the question of bifurcation of the appellant's village, namely Borshibanda and Goladigli Part 2. This appeal is accordingly disposed of by modifying the impugned judgment and order dated 23rd August 2024. Server.
Number 2 to 4.
Marks of the Mr. Banerjee, just a short pass over.
Yeah. Sir.
Item number 5.
May I please, Your Lordship? Well,
Yes.
here, the issue, earlier, my lord, as directed by this court, my lord, I approached the family court at
Yes.
Dhubri, my lord, and I made appropriate application there. But the learned principals of family court, my lord, returned back the application with the remarks that I have to approach the, my lord, appropriate court, my lord. This is the observation of the note of the, my lord, principal judge. My lord, I have the original copy that was returned back to me, my lord. Lordship, so, my lord, here the issue is, my lord, the victim
No,
is
you show us the order. That court is supposed to decide.
no formal order has been passed, my lord. My application has been returned back, my lord, with a note that
Where is the note?
my lord, that already, my lord, this is the original petition copy, my lord.
Which is the proper court?
My lord, even there is no formal order, my lord. There is no formal order. This is the note, my lord, put by the principal judge with the direction that I have to approach the proper court, my lord. Now the issue here, my lord, lordship,
No issue. The court has to decide. This is the most irregular practice the court has. We do not know who has signed this.
my lord, at the backside of page number 7, my lord, this is affidavit portion, my lord. There is a seal of the court also, my lord. When the application was filed, my lord, there is a seal of the court. My application was accepted,
This is the stamp reporter's seal.
my lord, of the court, my lord.
Who has made this endorsement?
This is the first column, my lord, the first page, my lord. The note is was given by the principal judge, my lord. Principal judge herself, my lord. Dhubri, my lord.
We are not accepting this note. It has to come under proper seal and signature.
then, my lord, I can file one additional affidavit. Along with the additional affidavit, my lord, I can place this, my lord.
Brother, we are sending it back. Yes.
A similar issue, my lord, there is a judgment of the Honorable Supreme Court, my lord, on a similar issue. It was, my lord, it is a full bench judgment. If I am permitted, my lord, I can place one judgment of the Honorable Supreme Court, my lord.
Yes, please take down. Reference may be made to our order dated 25th April 2025. Paragraph. This matter has been adjourned from time to time to ascertain the results of the proceedings in the court below. Paragraph. We are quite surprised to read a note dated 19th June 2025 on the front page of an application purportedly under Section 43 of the Guardians and Wards Act 1890 for enforcement of the order dated 27th September 2024 of the Court of the Principal Judge, Family Court at Dhubli. Full stop. In handwriting, it is inscribed that the petition be filed in the proper court. Followed by an initial. Full stop. Learned counsel for the petitioner states that this writing and initialing is by the learned principal judge. Directing the petitioner to file the application in quotation, the proper court. Paragraph without the seal of the court. Without the seal of the court and without full signature, we are unable to ascertain whether it is signed by the learned principal judge at all. Paragraph. Whatever may be the case, on the basis of our order dated 25th April 2025, this application is to be taken in the file of the court and dealt with in accordance with law. Full stop. Even if it is to be presented before another court, a proper order to that effect has to be pronounced. Paragraph. On the basis of this order, we direct advocate for the petitioner to present the petition in the court of the principal judge, family court at Dhubri, who shall accept the same, direct registration of the case, and deal with it as directed by us above. Paragraph. We make this matter returnable on 6th August.
Lordship. All right.
Item number 6. My lord, service report is awaited on respondent number 4 and 5.
Review application.
My lord, this is a review. My lord, there is an application for continuation of delay. My lord.
The other respondents have been served.
My lord, no, my lord, on respondent number 4 and 5, my lord, we have taken steps, my lord, the service report is awaited, my lord.
But what about the others? 1, 2, 3?
1, 2, 3, we have already served, my lord.
All right.
On the last date, they appeared, my lord.
Condonation of delay.
My lord.
In connection with the review application.
My lord.
This application for condonation of delay in connection with a review petition is adjourned till 30th July 30 to enable advocate on record for the petitioner to file an affidavit of service with regard to service upon respondent numbers 4 and 5. Full stop. The respondent numbers 1, 2, 3 have already been served as submitted in court. Have you filed an affidavit of service?
No, my lord, will be filing, my lord, before the next date.
Then you write to file adjourned till so and so date to effect service upon respondent numbers 4 and 5. Learned counsel for the petitioner states that respondent numbers 1, 2, and 3 have already been served. A comprehensive affidavit of service should be filed before the returnable date.
Item number 7.
Meet, please, Your Lordship.
Yes.
Lordship, this is that PL regarding the constitution of minority board in the
Yes.
state of Meghalaya, Lordship.
Yes.
On the last occasion, Your Lordship have directed us to take effect steps on respondent number 6 and 7, Lordship. That is the Union of India, Lordship. Now, we have taken steps, Lordship. However, Lordship, we are yet to file the affidavit, Lordship, being reported, Lordship. And also,
What step? Service?
Lordship. And the state, Lordship, on the last occasion, the state respondents were required to come with the status, Lordship, as regards to the Lordship instructions with regards to the The 2016 recommendation, Lordship.
Lordship will recollect by the order of 1st July, we had raised a preliminary objection, Lordship, on the ground that the letter was forwarded by the member secretary to the President of India. And there was a forwarding letter regarding the report, 52nd report. So our contention was that, Lordship, whether that has passed the test of Article 350A or not. Article 350 said that the President has to reroute back after both Parliament, the matter is discussed by both the Parliament and rerouted.
Yes.
So at that stage, Your Lordship, we said we don't have the information at this stage.
Yes.
Your Lordship was pleased to pass a very detailed order on 1st July, asking the Union of India to at least give a report on the 52nd.
Yes.
So today we in that stage, Your Lordship, the Union of India is not represented. So we still don't know the fate of that communication made to the President of India and what is
We
the
have
legal
not served
status
them
of
up to
52nd report.
Lordship.
We have not served them up to now.
Lordship, we have served letter. We have effected service, Lordship.
Then
We are yet to file the Lordship affidavit of service, Lordship. Lordship. Lordship may kindly grant us a week's time. Lordship will file the affidavit of
so
service.
they have received.
Lordship, that we'll have to ascertain from the GPO, Lordship.
All right. This public interest litigation is adjourned till 22nd July to enable the petitioner to file an affidavit of service with regard to service on
Respondent number 6 and 7, Lordship.
the central government. That is, I, respondent number 6 and 7. Advocate on record for the petitioner is also directed to serve a notice on the said respondents, informing them of the date of hearing of this matter.
Obliged.
Number 8 to 14.
But this matter, my lord, I'm seeking for some accommodation, my lord. Here there was a connected review filed, my lord, against the same judgment. Well, the review was heard yesterday, my lord, and the order is reserved, my lord. I was praying, my lord, if this matter could be fixed after a week.
How does an appeal lie if a review application has been filed?
No, my lord, it is by the different petitioners, my lord.
Same petitioner filed, my lord.
No, my lord. The review was, the appeal is being preferred by the association, my lord, whereas the review is being preferred by the individual entity.
Against the same common order.
Against the same order, my lord.
We have to see whether the same party or the same interest is pursuing two remedies at the same time.
No, it's not the same individual, my lord.
Same individual, my lord. Earlier association along with the individual member filed the writ petition, my lord. And when we objected, then association has withdrawn the review and the member of the association is continuing with the review, my lord.
No, before your lordship, my lord, before the, in appeal, my lord, the association is,
This is at the admission stage.
Yes, admission stage, my lord.
I was praying, my lord, if this matter could be taken up next week, my lord.
After 2 weeks, my lord, if my friend is next week, we have got holidays.
Learned Advocate General takes the point of maintainability. Full stop, he submits that a party who is similarly situated as the appellants has filed a review application before the trial court for review of the same judgment and order, which is the subject matter of this intended appeal. In such a situation, it is submitted that the appeal should not be entertained. However, this batch of appeals is adjourned till 11th. July, with a direction upon advocate on record for the appellants to produce the records of the review proceedings.
Number 15.
Yes, please.
Please, Madam. This petition relates to the implementation of the centralized providence scheme for the teachers of deficit granting college in the state of Meghalaya. By order dated 5/11/2024, this Honorable Court had directed the gazette notification of the scheme prepared by the government.
So this is ready for hearing.
My Lordship is ready for hearing, my Lord. The Lordship may have it after 2 weeks. In the meantime, we are trying to resolve the matter outside the court, my Lord.
The only thing that remains is the gazette notification to be made by the government regarding the scheme. This writ petition would perhaps
Become infructuous.
can be closed on that lines. Liberty for the scheme to be.
All right. On the submission of learned Advocate General, this writ petition is adjourned till 24th July. To enable his client to take steps for resolution of the disputes between the parties in this writ. Madam, we are leaving it at that.
Number 16.
May I just make a prayer on that, my lord? An observation.
Resolution is.
One observation that they can go for the gazette notification of.
We'll take
scheme,
steps because there are other. Resolution is good enough. That will cover.
I take his word, madam. Obligement.
Number 16.
What is this MC?
MCT
Is miscellaneous.
That was for modification of an order of that same order 5/11/2024.
All right. This writ petition and the connected application.
Yes,
All right.
I'm obliged.
May it please your lordships. Lordship, in this matter, I pray for some accommodation, your lordship.
Sorry?
In this matter, your lordship, I pray for some accommodation, your lordship, as the learned DHR has got some personal difficulty, your lordship.
Is otherwise ready for hearing.
Yes, your lordship.
What do you say?
So we can come up after 2 weeks.
Why 2 weeks at a time? Next week.
Lordship, any date, Lordship. Any date.
What is the problem?
Your lordship, he has got some personal difficulty, your lordship.
Who?
The learned DHR, your lordship.
You consent.
Yes, your lordship.
All right. By consent of learned counsel for the parties, this appeal is adjourned till 24th July.
Much obliged.
Number 17 to 31.
This part heard matter, my lord.
Part
Part heard from Wednesday, my lord. It was heard on Wednesday.
Most probably it will not be called on today.
My lord.
So
Let
shall
it
we
remain.
pass it over or pass it over for the day?
My lord,
Pass
let
it
it remain
over
in the
for the-
list.
You'll have to pass it over.
Then we will take it up on Monday.
My lord.
Monday is holy. Tuesday, my lord.
Tuesday, yes.
Tuesday.
This batch of appeals ready for hearing. Part it is part heard, huh?
Yes, part heard, my lord.
May be listed for further hearings. This batch of appeal has been partly heard. Full stop. Hearing is not concluded today. It is adjourned till 15 July.
Deeply.
Second call, item number 2 to 4.
3 to 4.
Yes, my lord. Lord. Also, this miscellaneous application we have filed for awarding the contract for opening of another central bonded warehouse, my lord. Because your lordship has seen the controversy in the connected matters that the allegation was that the monopoly has been created in favor of one bonded warehouse. In exercise of power under rules section 16, my lord.
With the greatest respect, my lord, we have not been served with a copy of this application.
Because this, you are not party to this petition.
We are, my lord, questioning the establishment of the bonded warehouse. 1 or 2, my lord, is the subject.
The central bonded warehouse, my lord, we want to create additional central bonded warehouse, my lord.
Well, then
Under
this
the rules.
Let
must go.
Mr. Shah, you serve a copy upon him.
Yes, my lord.
Let affidavits be filed. Today we cannot order for opening of another central bonded
My lord,
warehouse.
if I can place my facts briefly, my lord. We have under the section 16 exercised the power and issued the tender, my lord. That tender notification was, that policy decision was challenged by the existing central bonded warehouse, stating that there cannot be another central bonded warehouse. And we have the monopoly to have the central bonded warehouse, my lord. Your lordship heard the matter, your lordship permitted us to go ahead and float the tender, and if your lordship will kindly see the order which I have placed in my application, your lordship's order of 7th May 2025. And only second last paragraph of my application, my lord. Page 12, last page of my application, my lord. We are not going into any controversy. Taking into account the submission of learned, so we direct the respondent shall be liberty to proceed with consideration of the offers of application received further to tender issued inviting the same set up an additional central bonded warehouse. The respondent shall be at liberty to consider them and select a successful bidder tentatively subject to approval of the court. We make it clear, no agreement. So we have selected the identified subject to, and we are waiting for the approval of the court, my lord. And we are going to receive 2 crore rupees of license fee plus further revenue, my lord, and there is no legal bar. This is our right to create central bonded warehouse, and we have created. If somebody has right to challenge it, let him challenge, but they cannot be preemptive stay on my right to create bonded warehouse, my lord.
But Mr. Advocate General, that will snowball the...
No, because that will resolve, my submission is, my lord, that will resolve...
They agree with what? The second will come up.
The issue is, my lord, issue is that they are saying that I do not have power to create central bonded warehouse. And their ground of challenge before your lordship is that it is creating monopoly in favor of private entity, my lord.
Mr. Advocate General, please hear us.
Yes.
This interim order will continue. This let affidavit be filed. This application will be heard along with the appeals. We will dispose it up together. If you succeed in the appeal, why one? You open 10 central
Because this
bonded.
is not by challenge by the ISWAI, my lord. ISWAI has not challenged this part, my lord. There is no challenge to it. It is challenged by the existing bonded warehouse, existing central bond. ISWAI is not challenging. So how can they file the affidavit in my writ when they are not challenging it, my lord? They are challenging the other one. They are saying there is no challenge in this case, my lord. My submission is this, my lord. If they want to challenge, they should file intervention application, challenge it, file separate petition, my lord. Tender was issued, we have invited the bids, we have done everything, my lord. And ultimately, if they succeed, my bonded warehouse will be closed. The prima facie case is in my favor. Balance of convenience is also in my favor. If they succeed, your lordship finds that I have no power to set up central bonded warehouse under the act, my lord, it will be shut down, my lord. But the private manufacturers cannot say that I can't have bonded warehouse. We have 40 bonded warehouse and 1 central bonded warehouse. We want to add 1 central bonded warehouse, my lord. With respect, my lord, they cannot intervene at this stage and say that government cannot set up unless they challenge it. And there is no challenge to the central bonded warehouse. And challenge was by the existing central bonded warehouse. So my respectful submission is, my lord, it is my right. My right should not be curtailed on apprehension, my lord. And I will be getting huge revenue, my lord. They will be paying 2 crore rupees of, plus we will have excise earning also, my lord. But if I don't open it and the grievance is that existing central bonded warehouse is not in position to meet the requirement, this will also take away their challenge, my lord. And this has originated from the orders passed because your lordship has asked us to take care of the monopoly aspect. A committee was constituted, committee has gone into...
Say for example, Mr. Banerjee yesterday showed some papers where the existing central bonded warehouse was not taking any commission. 0.0000 he showed.
Yes, madam.
Now suppose there is another one.
Yes, madam.
Now you can't predict from now that they will also charge 0.
My lord, so far as the commission is concerned, my lord, commission is one aspect of the matter. Who will charge what is determined by the market forces, my lord. And that on the basis of, my lord, whether who will get what, my policy is, they have to show that I don't have power. I have power to set up the bonded warehouse. 40 bonded warehouse are functioning, my lord. We are giving commission to them, and one bonded warehouse also is functioning, my lord. They are getting the benefit.
May I have a lordship please to make one submission, one very short submission. Well, I've heard my learned friends. Well, our challenge was to, my lord, the amendment to the excise rules and the bonded warehouse rules, where, my lord, the state had decided that, my lord, one central bonded warehouse would be set up. Now, my lord, as soon as the state now, my lord, takes a position that not one but 2 central bonded warehouses will have to be set up, the entire, my lord, challenge, my lord, must succeed. Well, thereafter, if the state seeks to do something else, that is up to the state. We shall decide on whether to challenge that or not. But as of now, the state stand is very well. One bonded warehouse cannot exist. We need 2. Well, that itself, is succeed. Is ground enough for ultimately allowing a writ petition.
And Mr. Shah is intervening in matters where he is not a party. Let me also make some submissions. Mr. Shah is not a party in that. My lord, the question raised by Mr. Shah was that there was no power to have a bonded warehouse at all. If he succeeds in that, the second one will go, the first one will go.
All 40 bonded
The question is not whether, my lord, if the power exists, the question whether the second one can come or not is not the issue before the court. This is not a correct submission at all. His power, his challenge was...
When you propose the next date of hearing to be, Mr. Shah and Mr. Banerjee, because we want to finish this matter.
Well, today your lordship has it. I mean,
yes, and thereafter?
I was having some difficulty. I wanted it on the 5th of August.
You fixed one matter on 26th July?
We all know, the difficulties, with that. Your lordship wants to finish the matter. We are very eager that the matter should be finished.
But I have some difficulties, my lord. Otherwise, your lordship may keep it on the 24th of July for one day, my lord.
No, you are coming for that PIL?
That is 24th of July.
We will keep it on 24th of July?
But you will keep it. That's early enough, man. Of course, today also I'll make some...
short affidavits be filed, Mr. Advocate General, and we will...
24th, your lordship, kindly hear me.
We will take the decision.
Yes, sir. On 24th.
Okay, please take down. Let a copy of this application, WPC number, no. Is it this application, 430?
430 is writ petition and miscellaneous application is 158 of 2025.
Well, kindly pardon me, but your lordships had on the last occasion indicated that 22nd, 23rd and 24th of July, your lordship would hear this matter so that the matter can be finished.
Yes, we can. I was asking Mr. Banerjee because yesterday I fixed a PIL on 24th where he is appearing. That is why.
Yes, Lordship keeps it on 24th only, man. If necessary, we can continue. Your Lordship keeps... I have some difficulty on the earlier day.
All right.
I don't think your Lordship had fixed it for 3 days, subject to correction. Mr. Shah, of course, never makes an incorrect statement, I know. But
no, your Lordship will indicate that, but the order does not record it. But that is what my
I go. Mr. Shah says something. I'm
all
sure.
Right.
As I know him.
Let a copy of the application, the present application. Be served on all parties in this batch of appeals, including the client of Mr. Jishnu Shah, and senior advocate. Who is your client, Mr.?
The ISWAI,
ISWAI.
International Spirits and Wines Association of India, ISWAI. ISWAI.
We'll serve the council. We'll serve copies on the.
Yes. By 15 July, 14 being a holiday here, let affidavits be exchanged according to the following directions. Affidavit in opposition by 18 July. Affidavit in reply or rejoinder by 23rd July. Let the application be listed along with the batch of appeals.
Wait.
Yes.
You have to place the petition.
Yeah.
Thank you.
Yeah.
My lord, before I proceed with the, continue my submissions, one small point has to be clarified, my lord. I'm sorry. Mr. Shah is here, is good. On this application which I had made, is the miscellaneous application 13, where I had given the figures of zero commission. Your lordship has seen it. Yes. I was hearing, we nowadays have the, fortunately, the ability to hear what was argued on that day because of the recording. So I was hearing the recording of Mr. Shah, and apparently this is what happened. I'm sure Mr. Shah will not dispute it. This application was moved on the 7th by us, miscellaneous application 13. And then on the 10th, the matter was heard, 10th of February. Yeah. And of course, Mr. Shah, from his client's point of view, rightly pointed out that this is very belated. So many affidavits have been filed, the matter has been pending for so many years, and now the state is coming with this additional application, putting on all these things on record. And he made that submission. But I had also pointed out that this is a very important part of the matter, because question of the commission and the margin shows that, according to me, the locus standi and the financial injury. To which he then responded that it was a very minor part of his case. To which I said that if you're going to give it up, there's no difficulty. And then he said, no, nothing of the sort. I have no intention of giving it up. Then I said, I'm quoting from what I've just heard about half an hour ago. Then I said that in that case, if he wants to file a response, then he can do so to that. To which he answered that not necessary, because he's only going to hold up the hearing. And that's where it rested. And he thereafter made a submission on that. He said, apart from saying it was not a major part of the case, he also said that the fact that margin has not been levied today does not mean it cannot be levied tomorrow at any stage after the writ petition. I'm going exactly by the submissions as I've heard them. So this is the situation. So I proceeded under the impression that this petition, it's in the petition, it's really an additional affidavit, additional documents, is on your lordship's record. He has responded to it. Your lordship has taken note of it. Now, yes, yesterday, of course, Mr. Shah never made the statement. One of his juniors said, I heard some murmuring that what is the question of responding to it and what is the need to respond when no notice has been formally, it has not been formally admitted. Now that I found, therefore, if that, I do not want it to get into controversy. He has made submissions. Kindly formally admit this application number 13, which is already on the record and has been argued at length. I do not want it to be said at any further point of time before any court. I'm sure that will not be the standard before this bench, because that this matter, this rebuttal was not given to the zero margin because the application was never admitted, so the occasion for rebuttal never arose. This should not be said. I'm not saying Mr. Shah has said this. He said it is not necessary.
We are aware, Mr. Banerjee, of admission of writ petitions, admission of appeals.
This is a miscellaneous application.
But when the main writ has been admitted, I have not heard of all miscellaneous applications also admit.
Your Lordship will record this miscellaneous application is taken on record, and no counter has been filed. Kindly record that no counter has been filed, and there is no requirement. They do not.
Passed our order.
You pass. Very good. So Lordship will cognizant because this is a technicality which I do not want to erase at any later point of time. So that's the first. The second point is, my Lord, notification. This notification should have been really placed, well, by us and by the petitioner both, but somehow it has missed. I just came to know about this. Give him also a copy. Apparently this period, and this is a government notification, gazetted notification, so this is not an internal something of the government. This should have been annexed by my learned friends in the petition, in fact. But I also say that this should have been disclosed earlier by us. So this really is an amendment on the 1st of June 2022. That period of regular supply of 3 months stock, your Lordship recalls, which Mr. Shah had placed from the petition, that the bonded warehouse, central bonded warehouse, must have 3 months stock. That has been amended to 1 month stock in 1st of June 2022 by notification of the government. This is a public notification. So I think Mr. Shah and my learned friends also, and your Lordship may take note of this, so that whatever that notification would stand amended to 1 month. Rule 44. Lordship kindly takes note of this, my Lord. The government notification, Rule 44. Whatever the consequences, my Lord.
You were placing yesterday all the sections.
I'm coming back. I'm coming back. This is just, I'm pointing out, there's one notification there which should have been placed earlier, because this amends the rules. My learned friend has relied on the 3 month stock. It is only 1 month stock. It appears from this. Lordship may take a note. I'll come back to this at the time when I'm dealing with that particular question. But my learned friends should be aware of this notification because they have obviously missed it. It's not there in their petition. Now, may I come back to, as your Lordship has said, those provisions?
Those country liquor and tari and...
Yes. Very, very interesting, my Lord. I'll come back to that. My Lord, for ease of reference, may I give your Lordship this exercise manual, because this has got everything, my Lord. And may I also give your Lordship, this is part of this manual. Page what? Running page? Page 324. No, it's not 324, brother. The chart, this thing. It is 320.
320.
Yes. You have more copies? Not necessarily.
No, I'm doing 2 copies.
You need one? I'll be showing you this also. Part of the manual. So, may I come back, my Lord, to the sections. Yes, section 4, it's very important, and it also, as per your Lordship's observations, section 4, kindly see. It will shed a lot of light on section 19, which has been argued at length by Mr. Shah. In fact, that is the only legal challenge. Mr. Shah has said section 19 excludes the right of the state of Meghalaya to make any delegated legislation regarding any bonded warehouse if it is exclusive in nature. That's the argument. Kindly come to section 4. Power to define country liquor and foreign liquor. So what is country liquor? What is foreign liquor can be defined. So then may I summarize like this, put it like this, my Lord. There is intoxicating drug like charas, there is country liquor, and there is foreign liquor. A, B, and C. 3 categories I am making. Kindly. Now, Your Lordship comes to page. This definition of country liquor and foreign liquor has been done by the government. Page 320. This relates back to when this orders. Any idea? Date.
320.
God, what is the date? Oh, 45, pre-independence. Okay. I'll also, on a lighter note, invite Your Lordship to consider this, that these rules and act were passed by the British government. The British government, of course, a historical context. I'm not saying this is one of the major parts of my argument, by no means. But if you see the statute, it was at the time of the British government, and the British government did not, one hears, at least as parts of history, did not consider liquors as res extra commercium and damaging to the health and contrary to the directive principles and such things. I mean, a glass of whiskey was not considered to be in any of these categories by the British, who presumably sitting in the Shillong Club or wherever it was, were part of that culture. So what they considered dangerous and what the government of India considers dangerous and what we consider dangerous may not have been identical. But as I said, this is just a passing comment. Now, why this is interesting is now kindly comes to page 320. And this is a classification done as far back as 1945 when they framed that section 19. So what is liquor? What's country liquor? What's foreign liquor? Very interesting. My Lord has page 320.
Yes.
I've given a copy to my learned friend, extract. It's part of it's a notified notification. So liquor, country and foreign. So what comes under foreign liquor? Fermented goes to wines. If you ferment liquor, then fermented is from fruit stroke wines, champagne, claret, port, cider and sherry. One category. And if it comes from grains, the fermented liquor is ale, stout, beer and perry. This is fermented. And if you take the distilled, which is the right branch, then you get all these things: rectified spirit, whiskey, brandy, rum, gin, and then of course denatured spirit, which is not potable alcohol, ordinary and special. So, just taking it in the context, these, at least in the context of that period, or possibly even now, cannot be said to be, at least they were not considered to be inherently so dangerous, because after all, when whiskey or brandy or rum is being produced, they are being produced by large established distilleries. These are not made in local houses in the back of the house in some barrel, country stills as they call them. These are established products by established institutions. This is foreign liquor. Now, in contrast, kindly come to the country liquor, left side. Country liquor is distilled is plain country spirit, spice country spirit, and fermented is tadi and pachwai. Now your lordships have heard.
You've seen the shops here.
Yes, I've seen the
shops. Side by side.
Yes.
One foreign liquor, and by the side there is a caption: local brew.
Local brew, right. My lord, this state of course is quite advanced in, my lord, these
local brew. Dozens, scores of them.
Now, in states where the thing is less well run, I mean, this state is well run, so we don't hear of those ghastly incidents. But in states, other parts of India, northern India, particularly, your lordship will hear of these tragedies where people have gone blind or have died because of country spirit being, not contaminated. This, that. I have not heard of any great tragedy where people have died in large numbers of drinking contaminated whiskey. I don't know. Certainly, I have not come across it. But I'm merely pointing out why this exercise is that evidently, at least in 45 and even in today, country spirit is capable of being somewhat more risky and dangerous than foreign liquor, which is a much more controlled and organized commodity. Although country liquor is also licensed, there's no difficulty. Therefore, the point is that intoxicating drugs and country liquor were treated in one category, and foreign liquor was separately treated in a different category. Because as your lordship had observed, that these things are, tari and pachwai and such things are inherently capable of causing a lot of damage to the system, community, people, whatever. These are things which have to be strictly, the quality and all that have to be strictly controlled.
And another version of it is called Bangla in
Bangla, yes. That is, I think, I am not that well versed at this equivalent. I don't know whether Tadi and Bangla is the same. I don't know. Mr. Shah may be able to enlighten me on this.
No, all of them together, taken together, are called hooch.
Yeah, hooch. I am obliged. Absolutely. All of them taken together is called hooch. Now, I have once upon a time experimented by trying a little of this hooch. Is a highly noxious substance which is, I had to immediately go and flush it out of my system in the local closest toilet. Anyway, so the point is that the British did not treat tari and whiskey as the same type of liquor. Let's put it this way, put it bluntly. Tari is not something they'll be sitting in the Shillong Club and imbibing. They're not the part of the cultural life of England or British India, possibly. This was for, as they would put it, the lower bracket of the inverted comma natives or whatever. I mean, in the class distinctions of that time. So whatever it is, these were treated separately. This is 1945, 1910 we are talking about. So this country liquor and foreign liquor, why I am making all these distinctions is, kindly come to now section 19.
I don't know. Tari may be made of this date palm jaggery, fermented.
Maybe.
I don't know. Is it rice or?
That's what I'm told. That is correct. Yes. Fermented jaggery.
It's basically, it comes out from that date trees.
Or date trees.
During the night.
Yeah, during the night.
Yes, they
try this
slice. They slice the trunk and place a pot.
Yes,
hang a pot.
Yes,
and which corrects it throughout the night, and then they bring it down.
My friend is saying toddy tapping. It's basically toddy tapping. Basically toddy.
And then when you boil it to a certain degree, acceptable degree, then it becomes jaggery.
Yes.
It is absolutely sugar-free, but
yes,
and delectable to taste. And then when you take it further, then it becomes intoxicating substance.
Lord, I am teetotaler, so therefore I have no idea. I am completely teetotaler.
Only thing I'm pointing this out on the way, but I'll come to the main section 19 later, that in the section 19, the legislature of the time, which is 1910, has treated intoxicating drugs and country liquor as separate from foreign liquor. And your lordship had observed very pertinently that intoxicating drugs and foreign country liquor are both dangerous in nature. That is why they have been kept separate. Section 19, your lordship, when I come to it, I'll show your lordship. There was no other reason for separating them from foreign liquor. No perceptible reason. I can only presume that it was, but it has been separated in a different class. There is no doubt about that. My submission would be possibly because of the nature of because intoxicating drugs definitely are highly damaging, and if you class it with country liquor and separate it from foreign liquor, I would draw the conclusion that the legislature felt that these two are operating in the same field.
No, both are intoxicating.
Yes, both are intoxicating.
But then this local thing becomes poison.
Correct.
Sometimes very poisonous and kills within few hours.
That's right. That will not happen with your Scotch whiskies or local whiskies, for example. That is, you can keep them for years together. They will not deteriorate to toxicity. So That's maybe one of the reasons. I'll come to that in section 19. I'm only pointing out in passing that why this definition of country spirit, country liquor and foreign liquor has been given, so your lordship can appreciate what are the things which are country liquor and what are the things which are foreign liquor.
That is the bane of poor people in India.
That's right.
They don't have money for food. They don't reach any money to their families. They don't have food. And you will find them lining up in
for
the
this country spirit.
This country spirit and getting...
Therefore, the British felt that there should be some control on this bracket of liquor. That's what I'm coming to. The British felt, or rather the government of India, I shouldn't use the word British, technically the government of India. The government of India in 1910 to 1945 felt that there should be some specific control on this category of country spirit, and along with that intoxicating drugs. If at all it is to be permitted, they should be treated separately. And that is why I will show from when I come to that, it's only one supplier who can give to that region. It has got nothing to do with warehousing. It has got nothing to do with the retail vendors also. You can have 10 warehouses, you can have 10 retail vendors under section 19. I'll show that to my lord. But one supplier. I'll come to that, man. Because that is his basic argument on that, was that section 19 gives exclusivity only to this category, and therefore now you cannot extend that exclusivity to other category of foreign liquor. That is the basic argument. I'll deal with that. Now, I am now at the point of showing your lordship what are the definitions and what is the precise power, because my learned friend, his legal challenge is there is no power of the state to enact this, to pass these, enact these rules. So, country liquor and foreign liquor definition your lordship has seen. Now, kindly come to Chapter 3, Section 10. No intoxicant is all categories, shall be imported unless the state government has given permission, general or special, for its import. Conditions may have been satisfied, duty has been paid, a bond has been executed. Section 10, your lordship has seen at page 11 of this compilation. My lord?
Restriction on import.
Yes, I'm just placing the relevant provisions. Import means import from outside the state cannot be done without the permission of the state government. Not a proposition in dispute. My lord, then section 12. State government may prohibit the import of any intoxicant. That's the power to prohibit. Like the state of, say, Nagaland has now virtually prohibited the import of any intoxicant. Prohibition states. Now, 13 is passes for import, export and transport. I may note in passing that the Supreme Court has held, though I don't need it specifically for this case, that prohibition power includes the power to regulate. So, then paragraph 13. Passes for import, export and transport. Here also the no intoxicating exceeding such quantity, etc. Applies, or local shall be imported except under a pass issued under the provision. So transport pass will be needed. Now, my lord, most important, relevant for our case, chapter 4. Kindly note chapter 4. Because the contention is there is no power to establish the central bonded warehouse. Lordship kindly sees. Manufacture and preparation for manufacture permitted only under license. So this is section 15. No intoxicant manufactured, no hemp plant, no liquor shall be bottled, no distillery, etc., no person having material, etc., unless and until notified so and so. Tari, fari, etc. Then, section 16. This is the most important. Specific conferment of power. My lord, I would submit before my lord, when there is a specific conferment of power, no sort of collateral implication, all these arguments. This is a specific conferment of power. Section 16 of the Act kindly says, establishing or licensing of distilleries, breweries, and warehouses. The excise commissioner, with the sanction of the board, etc., is 1. Establish a distillery. B. Discontinue the distillery. 3. License whatever distillery. D. Most important, specific power. Establish or license a warehouse wherein any intoxicant may be deposited and kept without payment of duty. So under section 16D, specific power is given to the state to establish a warehouse. A warehouse means any warehouse. Specific power. Mr. Shah is, in his submissions, is trying to carve out something from section 16D, saying, yes, section 16D is there, but the moment you have an exclusive warehouse for any area, maybe one district, maybe two districts, maybe the state, maybe half the state, moment you have a warehouse for any area, specified area, then 16D will not apply anymore. You have no power to license or open that particular warehouse. Lordship kindly appreciates the argument made by the petitioner. Based on section 19, according to him, section 19 overrides all the specific and general powers in the statute to establish a warehouse. Section 19 impliedly excludes any warehouse where foreign liquor can be stored if it is exclusive to a local area, as I have understood the argument. Now, I am pointing out that section 16 gives the specific power. Then 17 and 18 are prohibition of sale. Then 19. I will go through the section and then I'll come back to 19. 19 is, my lord, very important in the sense that this is the statutory challenge of the petitioner. As I take it, really the only statutory challenge of the petitioner, because the rest is all based on speculations and apprehensions. I will demonstrate that. But the statutory challenge of the petitioner is section 19. And may I place this?
Yes, please.
The state government may grant to any person on such conditions and for such period as it may think fit the exclusive privilege of manufacturing or supplying to licensed vendors. May I read it slowly, my lord? The exclusive privilege of manufacturing or supplying to licensed vendors. So what is the privilege? You manufacture and supply to licensed vendors. VENDORS. So vendors are not singular. If I am clear to my lords.
Yes.
Any number of vendors. Vendors are the retailers. Vendors are the people whom the customer reaches. The vendors are the retailers, the shops. So you can have multiple vendors. But the supplier will have an exclusive privilege of supply. Manufacture and supply. May I go a little slowly on this, my lord? This needs a little understanding.
Country liquor or intoxicating drugs?
Yes, country liquor or any intoxicating drugs. What is the restriction? What is the restriction?
Now, the definition of intoxicant.
Intoxicant is the widest category. Intoxicant is category A, B, and C, all three together. Intoxicating drugs, country liquor, foreign liquor, all three together add up to intoxicant. That is, my lord, subsection 12 and subsection 13 of section 3. Your lordship may go back if your lordship is at page 7, your lordship. So intoxicant is everything. Drugs, foreign liquor, country liquor. I believe on this there is no issue, my lord. This is the definition. Now, out of these three categories, two categories are singled out. Which two? Country liquor, intoxicating drugs. The word intoxicant is not used here. Therefore,
Yes.
exclusive privilege is for supply of country liquor and intoxicating drugs. So I can designate district Shillong, say. There is a district Shillong, I think. East Khasi. Very well. I can designate notionally East Khasi area hills is one district. East Khasi Hills district. I the state government designate that in that East Khasi Hills, I am giving the exclusive right of supply and manufacture to, let us say, Diageo for certain brands. That cannot be done according to him. So for country spirit, certain East Khasi Hills for country spirit and intoxicating drugs is allotted to Mr. X. One Mr. X will manufacture and supply to the East Khasi Hills. One Mr. X exclusively. That is section 19. Kindly see it again. Page 15.
The definition of country liquor has to be taken from page 320.
Yes. That's right. Notified, don't dispute. So now that's why I showed your Lordship page 320 in detail. Your Lordship can now understand what is country liquor, what is foreign liquor. And that country liquor, as in page 320, and intoxicating drug are taken in one category. And the legislature says, listen, because of this particular category, I can restrict a local supplier, a local area, say East Khasi Hills. Supposing I feel East Khasi Hills is more prone to these problems which your Lordship indicated, the local population sending all their salary on the first day and all these things. Suppose I'm giving your Lordship a notional illustration.
Not only that, they create a brawl there.
Domestic violence.
They will
Yes,
stumble and fall on the road and go back home and beat up their wives and children.
Right. And spend the salary while they're about it.
Yes.
So supposing the government of Assam, feel that East Khasi Hills, this is an area where this problem is very acute, a local area. Then what I do is, I do not restrict the retailers, the vendors, as your Lordship seen. Vendors are okay. The shops, I am not going to restrict the shops in that area. I am not going to restrict the warehouses in that area. I'll come to that reason also. But I will make sure only one supplier. So 10 different brands, 10 different people cannot supply that country spirit to one supplier for the local area. One, you can manufacture and supply in that area, one person only, exclusive privilege, manufacture and supply. Have I made it clear to my Lord? Because of the inherent nature of the thing being supplied, that's of course my interpretation, my submission. But what is beyond dispute is, for this category, one manufacturer and supplier only for that area. So I designate that area. By the way, this has never been done. This is a provision which has never been actually given force to, but that's another matter. So I have the power to say one supplier only.
Yes.
So by that means I control to some extent the quantity and quality of what is coming into that district. Because there are quantity checks and all those things are there. Lordship appreciates. Exclusive privilege of manufacturing and supplying to the licensed vendor. Kindly see. The exclusivity is for the manufacturer and he will supply the goods. Exclusivity is not for the vendor. Vendor may be many. Vendors. DORS. So the supplier come manufacturer is exclusive. Now the question is,
Now, if manufacturer, supplier, according to Mr. Shah's argument,
includes warehouse also, has to, according to him. Because if otherwise the argument will not work. Because what he's saying is that exclusive right which is given
may
for
be
country spirit
exclusive
in this.
under section 19.
Yes.
So why in exercise of powers
Yes.
under section 19 or not exercising power under section 19, like whatever setup was there is further diluted by creation of a central.
If I'm understood, his argument was,
by addition of another, let us not say that the central thing is a manufacturer, but is a supplier.
Right. Now, the question therefore is it a supplier or not within the meaning of section 19?
Yes.
Well, that's the question. If it is
from the manufacturer to the supplier to the
that I am very grateful. So the question is, if
here there is a lateral tier of central whatever.
My learned friend's argument is this: expresso unius. Section 19 says you cannot designate in any local area a specific licensed warehouse. You cannot give an exclusive privilege based on section 19.
Yes.
Because that exclusive privilege can only be given for country spirit and intoxicating drug. No exclusive privilege can be given for foreign liquor. This is a simple proposition, my lord, according to him, which according to him follows under section 19. Since section 19 says exclusive privilege for country liquor and intoxicating drug, therefore it is implied that no privilege can be given for anything to do with foreign liquor. This is the argument, man. Now, we are concerned here neither with manufacture or supply, but with warehousing.
I've tried to follow your argument that as far as foreign thing is concerned, it is institutionalized, branded, and manufactured under proper care, and those brands are well known over the world.
That's the substance behind.
But as far as country liquor is concerned, it is indiscriminately made and dangerous, poisonous, etc. by unknown people.
Therefore, the intention was never.
Some regulation is necessary by delegating this manufacturing and supplying to one
person. It has got nothing to do with warehousing. That's the next question. Nothing to do with warehousing. I'll show your lordship. When I show your lordship the provisions of the rules, it is one supplier, many warehouses, and many vendors. I'll show your lordship the rules. It does not contemplate any exclusive privilege by giving one warehouse in a local area the right to store. Mr. Shah's argument is, warehouse also is included in the definition of supplier. Therefore, what is intended is there must be only one. If there is one warehouse in a local area, then that can be only for this country spirit. Lordship appreciates.
Yes.
So the question is, does this section 19 exclusive privilege apply to warehousing or not? Is it one warehouse only which can be given an exclusive privilege or not under section 19? Is it extending to supplier manufacturer only, or is it extending to exclusive privilege of one warehouse? Does the word warehouse come within this? Because warehouse is not mentioned. Warehouse is being brought in by an extended definition of supplier. So that is totally wrong. Warehouse is not a supplier. Supplier is the manufacturer and the person who is the person who creates the distillery. And I will show your lordship that under section 19, the supplier cum manufacturer is defined as, word is contractor. And that contractor delivers his country spirit to not one warehouse, but multiple warehouses. Lordship appreciates. So that privilege is of the contractor cum supplier. There is no concept of one warehouse exclusive privilege at all. Lordship will continue on the next occasion, or because that will take some time. I mean,
You must.
I can continue. I can show your lordship the rules. Continue. There is no difficulty. But if your lordship is rising, then I will.
No, but how much more time you're likely to take?
This will take some time, my lord. It's a lot of time.
No, how many hours in terms of arguments?
At least, I don't know, 5 to 6 hours it will take.
More.
More, yes.
So today.
Because I will go through the powers, then I will have to meet the argument on private monopoly, then I will have to talk about his case of discrimination under Article 14, that certain people have been favored and not favored. These are the major aspects.
Then after you, who will speak?
After me, say CBW will speak. CBW, I believe, is also appearing. CBW will be. Who is appearing? Mr. D.K. Mishra will be appearing for the CBW also. I don't know how long it will take. I'm just telling you all these are the facts.
So if you don't have much difficulty, we can, those dates which Mr. Shah was.
My lord, may I, can I do this, my lord? I know it's a little, can your lordship fix it provisionally? I can confirm it on the 15th.
No, you come on 24th and thereafter bring some collective dates.
Okay, very well. I'll do that. And this notification, your lordship kindly keeps, formally takes on record. It's a government notification, my lords.
Mr. D.K. Banerjee, Learned Senior Advocate, appearing for so-and-so in appeal number so-and-so. Resumes his arguments but does not conclude the same. The notification placed by him. The notification dated 1st June 2022. Of the excise : registration : taxation and stamps department, Government of Meghalaya. Handed up by learned counsel to court, is taken on record.
Copy has been given to the other side.
Yes. A copy thereof has been circulated to the
petitioners.
Yes. To the other parties, other appearing parties. List is batch of appeals and corrected applications for further argument on 4th July. Very good.
Obliged.